Good morning, ladies and gentlemen. Please be seated.
Your Honor, we are now calling United States of America versus Cliven Bundy et al. The case number is 2:16-CR-0046 GMNPAL. Beginning with Government Counsel. Counsel, please state your names for the record.
Good morning, Your Honor. Steve Myrie, Matty Ahmed, Aaron Cregan, and Nick Dickinson on behalf of the United States.
Good morning, Your Honor. Joe Cortese on behalf of Eric Parker, he's present in custody. Chris Rasmus on behalf of Peter Santilli.
And I'm not rising for a reason.
Good morning, Your Honor. Ryan Morwood, Payne, also present, or Brendan Drexler, Cullen Beck, Mr. Bader, and Eric.
Morning, Your Honor. Mr. Central representing Jason Wood is present. Good morning, Your Honor. Andrea Monty Hoskins,
Mr. John George on behalf of Todd Engel, who is present in the case. Eric Jackson, representing others.
Good morning, Your Honor. Colin on behalf of the Scott Presley. Good morning, Your Honor. Sean Perez on behalf of Ricky Love.
Morning, Your Honor. Chris Rami on behalf of Michael McGuire, who is present in custody.
Good morning, Your Honor. Mr. Stephen Stewart, who is present.
Good morning, Your Honor. Lee Sam Kowalski on behalf of Brian Cavalier, who is present in custody.
Angel Dow, standby counsel for Ryan Bundy. I do not note his presence in the courtroom, Your Honor.
Good morning, Your Honor. Dan Hill on behalf of Ammon Bundy, who's also not present. I assume it's something that we'll address throughout the course of this hearing.
Forthwith.
Hey, good morning, Your Honor. Dustin Marcello appearing for Mr. Gerald DeLemus, who is not present here.
All right. First of all, with respect to Mr. DeLemus and Mr. Cooper, they were not brought over because they have entered pleas of guilty and are awaiting sentencing. So the matters that are on calendar are not matters in which they are affected. But of course, Mr. Marcello, you're welcome to be here in court for these proceedings. With respect to Mr. Ryan Bundy and Mr. Ammon Bundy, I'm advised by the U.S. Marshals that they were transported here. However, they have declined to enter the courtroom. I instructed the Marshals that I was not going to ask them to use physical force to bring either of Mr. Bundy's into the courtroom if it was their election not to be present. Who will advise me of the current circumstances regarding Mr. Ryan Bundy and Mr. Ammon Bundy?
They are not cooperating.
Let's wait for a microphone, please. So it's, make sure it's on the record.
Ma'am, they are not cooperating. They will not walk into the courtroom on their own power.
That's incorrect.
Have they been advised that court is in session and that they are permitted to be present if they wish to be present?
Correct.
And have both of Mr. Bundy's indicated they did not want to enter the courtroom?
Yes, ma'am.
Has the Marshals lockup been set up so that they can hear the proceedings in courtroom through the audio equipment in the lockup?
Yes, ma'am.
Mr. Hill, if your client changes his mind and wishes to enter the courtroom, as long as he comports himself to appropriate courtroom decorum, I will of course allow him in the courtroom, and if he changes his mind, he need only tell the marshal in the lockup that he's changed his mind, and he'll be brought into the courtroom. But I'm not going to use physical force to make him appear if he does not want to. Ms. Dowes, Mr. Hill, have you had any advance notice that Mr. Ammon Bundy perhaps might not want to be present in the courtroom?
I think he wants to be present. I'm aware of the situation that's going on. I don't know if Your Honor would be willing to accommodate my having a quick conversation with those two. I think it might be able to be resolved and bring him in, but that's up to Your Honor.
Very well. If you believe that your intervention might influence them to come into the courtroom, I'm happy to accommodate you. Let me make some preliminary remarks and proceedings so everyone knows what we're going to do here today and how the court's going to conduct this hearing, so that before I adjourn, to allow you to confer with your client for that purpose.
Thank you, Your Honor.
So first of all, as I said, welcome to federal court. We are here today to hear some motions that are of significant concern in this case, and I have set this for oral argument, although the court's rules do not require me to hold oral argument in a case, so that I can ask questions of the lawyers. The papers in this case are very voluminous. I could not even carry all of the motions and responses and replies into the courtroom. So the papers are very voluminous. I assure everyone that I have personally read everything in this case, as is my practice, and I'm going to set oral argument not to have people reiterate the positions they've taken in their papers, but to ask questions to try to clarify the position. Now, this is a courtroom. It's not a sporting event, and so it's not an opportunity for people to make verbal or body language expressions of their support or their opinions. So I'd ask people to keep that in mind. I also ask you to please make sure that all cell phones and electronic devices are turned off and put away. We do not allow cameras in federal court. That's a nationwide policy in federal court. Many people disagree with that, but I am bound to enforce that policy. Put your cell phones away, do not have them out, and do not have them in use. If you do, I have instructed the marshals to remove anyone that has a cell phone out, whether or not it's in use, and anyone whose cell phone goes off during this proceeding will be removed from these proceedings. I do not want to see that happen. I want everyone to be here and see what's going on and hear what's going on. But just keep that in mind, please. That applies to the lawyers. And I will tell you that I have confiscated phones from FBI agents who forget or violate that order.
It should be.
And so the rule applies to everyone. Also, just let you know, we never used to allow cell phones in the courtroom at all. For many years here, and in many districts across the country, cell phones are taken at the point where you come in through the security place at the magnetometers and then return to you when you leave. We, in this court, relaxed our rules and changed our rules to allow cell phones because people use them so pervasively. We appreciate that the lawyers, especially in between courts or going from courtroom to courtroom, need an opportunity to be able to communicate with their office or their clients and so forth. So you can use your cell phones out in the hall or in other public spaces in the courthouse. You may not, however, use your cell phones to record audio or visual. I'm going to initiate proceedings here today. As you can see, we're rather crowded, and we're going to relax courtroom decorum in terms of addressing the court for the various motions that are on calendar by having all counsel and clients remain in place. So you will address the court from where you're seated. A courtroom staff member will provide you with a wireless microphone so that all remarks are on the record. And you can remain seated if you're more comfortable, especially if you have notes and so forth, rather than stand up and address the court. And that will help prevent a lot of time spent with movement and so forth, and make sure that everyone's remarks are on the record. There are a large number of matters on calendar. I'm going to start with a hearing on the motion to sever, and I'm going to initiate our oral argument by asking questions of the parties' positions. So let me do this. Let me briefly have everyone be at ease while I allow Mr. Hill to go into the marshal's lockup to communicate. And Ms. Dowse, you're welcome to go back if you wish to communicate with Brian Bundy as well, so that we can get your perspective of whether or not either defendant wishes to be inside the courtroom. So just be at ease, please.
The lady in Morgan. He can sell it. Yeah. He can sell it. He's voting on almost so much. So that's, I think, if you let everyone let your own see who can manage change, I don't know if you can do it and need to get the best
Can I file a motion to make America great again? Actually, I think we have a legitimate vote. We're not refusing. We're not refusing today. No.
You always come in here to see your fans. Probably how long more is here too. You know? Yeah, because I'm sure that your kids here. I know I want to see my family.
We're back on the record. The record will reflect Ms. Dowes and Mr. Hill have re-entered the courtroom. Mr. Hill and Ms. Dowes, if you'll resume your position, and I'll address you with respect to non-privileged communications with your client with respect to whether or not Mr. Ammon Bundy has elected to enter the courtroom. If you'll wait for the microphone, please. Mr. Hill?
Basically, Your Honor, it's their position that while in custody, it's the marshal's job to get them in the courtroom. I understand that Your Honor has instructed them not to use any kind of physical force to get them into the courtroom.
Will they enter the courtroom without physical force?
They will not, Your Honor.
They do not wish to enter on their own volition?
Correct, Your Honor.
So they're taking the position that the marshal should be forced to use physical force to bring them into the courtroom?
Well, it's a little more nuanced than that, Your Honor. I apologize. Basically, they say while they're in custody, it's the marshal's job to get them to the courtroom.
Do you have anything to add to that position?
I would just like to ensure, and I think one of the marshals is checking on it, that they can hear the hearing back then.
We made arrangements ahead of time. Marshal Montana, can you confirm that the audio system is in place and that both defendants are able to hear the entirety of these proceedings?
Yes, the audio is working properly.
Thank you. Ms. Dallas, do you have anything to add on behalf of Ryan Bundy as standby counsel?
No, Your Honor, and I am not authorized to speak on his behalf, Your Honor.
And are Mr. Hill's representations to the court accurate insofar as you overheard the conversations?
From what I understand, yes, Your Honor.
No, they're not. They don't want to be shackled, Your Honor.
Mr. Santilli?
Yes, ma'am.
You get to speak on your own behalf through your counsel. I am not going to allow people to interrupt or interfere with other people's positions. If Mr. Ammon Bundy or Mr. Ryan Bundy wish to take a position with respect to what has happened with being brought to court but not being in court, they may put that in writing, and I will consider it. But I'm not going to hear from somebody else about what you think their mindset is, okay?
Which is inaccurate. I just wanted to correct the record. Thank you.
Well, you don't get to speak on their behalf.
I agree. Thank you.
All right. So, we're going to turn then to the motion to sever, and let me make some preliminary remarks. As I said, I have read all of the papers that have been filed in connection with this case, and I do not need to hear the parties reiterate what you have put in your papers. I'm going to be asking questions so that I can clarify and try to reach the best possible decision. I've indicated in a written order that severance will be ordered because the court has concluded that it is physically impossible to try 17 defendants and logistically impossible to try 17 defendants in a joint trial in this case. And it is also the reality that a 17-defendant individual trial means someone has to go first and someone is 17th. And so that is the reality in which multi-defendant cases are tried. I'm going to have some questions here, and you do not need to convince me of what counsel for Payne and others have put in your papers in response to the government's supplement. It is indeed an untimely filed motion to sever. The case management order that I entered applied to the government as well as to the defendants. When I originally set an early deadline for filing motions to sever, I did so because at the first case management conference, I think it was Mr. Potter on behalf of Davy Bundy, initially brought up the fact that he intended to file a motion to sever in the case, and I think one or more other defendants also said they were similarly inclined. My thought process was that we would see, I set a deadline for filing motions to sever, so that we could see if there was a consensus among the defendants about what made sense to you about how to try this case, either as a group or individually. Almost to a man, the defendants' motions stated a couple of things. One, you wanted individual trials. And two, because you had only just received very voluminous discovery, you were not really in a position to evaluate severance, and you asked for an opportunity to supplement at a later date once your counsel and you had an opportunity to review the voluminous discovery that the United States produced in early to late May. So I waited to try to decide these motions to allow you to have that opportunity. It is not at all lost on the court that the government's supplement was filed shortly after the acquittals in the Oregon prosecution. And you don't need to convince me that the government has now taken a different position with respect to whether or not a joint trial is appropriate in this case. It seems clear to the court that the government expected a different result in the Oregon prosecution and expected that the results of that Oregon prosecution would result in non-trial dispositions for a large number of the defendants' claims. They now know that that is unlikely and that this case is likely to be tried with most, if not all, of the remaining defendants. So you don't need to persuade me about that, and I don't need oral argument about that. The government argued that the case, and it continues to argue, that the case was appropriately joined for trial under Rule 8 and was the paradigm case for a joint trial because it's a conspiracy case, and because in a conspiracy case all evidence against co-conspirators is admissible against other co-conspirators, and other reasons. And they also argued that none of the defendants who filed initial motions to sever had met any of the requisite showing that a brutal problem existed, that they were mutually antagonistic for exclusive defenses among the defendants that warranted severance, or that any defendant would testify in the trial of a co-defendant if depending on the sequence of the trial. So I understand all of that. It's equally true that the defendants, by and large, have also substantially changed their position. Whereas initially, most of the defendants sought individual trials, now a large number of the defendants are arguing, no, we'd like to be tried jointly. So both sides have, put neutrally, reevaluated where you are after many months of reviewing discovery and after having access to the results of the Oregon trial. So I appreciate that. I understand that. I don't need oral argument on that. I'm going to start with the government, and I'm going to ask, I guess initially, you've proposed 3 different tiers. The 3 different tiers of 3 separate trials coincide with the roles that the superseding indictment alleges the 3 different tier members played in the events that are charged in the indictment. You also claim that the order you propose, those that you believe are most culpable should be tried first, and that it would be an anomalous and unfair result for those who are least culpable to go first for trial. So the first question I have for the government is, why is it fair or just that those the government believes are least culpable should wait the longest for trial? Who will be addressing the government's position?
Your Honor, Steve Myrie on behalf of the United States. And, Your Honor, it may be easier for me to sit.
Yes, please. You're welcome. Anyone can sit to address the court. I know you have notes in voluminous matters.
It's hard to bend over to get the mic. So, yes, Your Honor, we're not necessarily wedded to the sequence. There was no real sequence, suggested in the responses. But in terms of...
You mean the defendant's responses to your proposal?
Yes, that's correct, Your Honor. It's hard to discern any particular order based on those responses. Our position with respect to sequence, though, is that in the absence of any other compelling reason, it makes more sense to go with the most culpable first. It could result in further efficiencies downstream of the trial, because we will have in the larger trial, I'll call it the broader conspiracy of the 5 that we've recommended in the first tier, we will have presented to the court and to a jury basically the evidence of the entire conspiracy. And as we put out in our papers, and as the court has already recognized, sort of the lower tier, the later tier people are less involved in all of the events culminating in the April 12th assault.
Right. So if I understand what you put in your papers and what you're arguing is that the trial of the 3rd-tier defendants, who are the least culpable followers and gunmen, would be the least expansive trial in this case, in that you would only need to summarize evidence of what the government alleges is the overall conspiracy leading up to the events of April 12, 2014 and thereafter.
Yes, Your Honor, that's how we anticipate the evidence coming in on the trials of those 3rd-tier individuals and part of the 2nd-tier individuals as well.
And with respect to the Tier 3 defendants, you would be focusing on where each individual defendant was and what their individual participation was, that you would not ordinarily do in a trial of the Tier 1 or Tier 2 defendants, correct?
That's correct, Your Honor. Although there are, in our proposed Tier 2, there are 2 that are also gunmen in the wash, as we allege.
Correct.
But you're correct. But there are only 2 in that group. But you're correct. Our evidence, we believe, will focus more on the movements of these individuals on the 12th in the wash vis-a-vis the law enforcement officers who are guarding the impoundment site. That's not to say, obviously, we'll be presenting other evidence as well of the prior events, but as the court's already acknowledged, more in summary form.
Right. And with respect to the Tier 1 and Tier 2 defendants, the government would not need to show the specificity that you would with respect to the Tier 3 defendants, because you would be relying more upon the mass movements of members of the crowd and the defendants, as opposed to where each individual Tier 3 person was.
Yes, Your Honor, that's correct.
All right. So why is it that the government believes that 3 trials would be more efficient than 2 trials, since the Tier 1 and Tier 2 defendants seem to be more aligned in terms of the scope of the evidence the government would introduce?
A couple of reasons, Your Honor. First of all, for the obvious reason that the more people you put in the courtroom, the longer it's going to take, just by the din of,
Sure, but that's how you decided to prosecute this case.
No, we decided to join the defendants in the initial indictment. I believe we've enjoyed enormous efficiencies by the joinder of 19 at the outset. I mean, here we are 9 months from arraignment, and we've pushed out a tremendous amount of discovery. Motions have been filed. We've been to the Ninth Circuit at least once, may have to go again. We've had third-party interveners. We've had, 40 motions filed. We responded to everything timely. We've pushed out discovery timely in connection with the court's scheduling order. So we've enjoyed enormous efficiencies. If these had been separately indicted, we would be nowhere near where we are today. Nowhere near. That's based on, common sense and experience.
All right, so if you had, for example, indicted seriatim, you would be starting from scratch with each individual group, is what you're saying?
Or if we indicted them simultaneously, yes. And we would be starting with 19 different case scheduling orders, 19 phased discoveries. It would have taken the government much longer to push out discovery. It would have taken, the defendants have enjoyed enormous efficiencies in being able to join motions rather than file individual motions. We don't know. So
I'm sure that they don't agree that you did them a favor, but
no,
I just
I'm
want
not
to...
suggesting that we did. What I'm suggesting is that the rules allow for judicial economy and judicial efficiency in the due administration of justice. And that's why, in this case, the rules allow joinder. Joinder was not only permissible, it was lawful, and it made enormous amount of sense given the magnitude
Right.
of
And
this case. Now,
I understand your position in that regard, and now we're moving to the next question, which is why doesn't it make more sense to have the Tier 3 defendants tried separately, perhaps first, and the Tier 1 and 2 defendants tried together second?
if we can, obviously we will do whatever the court orders, but from our perspective, it makes more sense to go with the Tier 1 first because of we will have presented the evidence, the subsequent trials will be much more efficient. We're not saying that the evidence is mutually exclusive as to each tier group. There's a lot of common evidence that will have already been presented. The court will be vastly familiar with in the other trials, so it will have all the evidence of the entire broader conspiracy by the time it reaches the gunman. The court will have a much better understanding, having tried that case, as to what the entire case is about and where everybody fits within it. Trying the gunman first, if you will, Your Honor, the court would not have the benefit of seeing the broader conspiracy and seeing how everything fits within the broader conspiracy. So we believe that it makes more sense from a judicial efficiency standpoint to go with the gunman because the subsequent trials will be much more efficient, the court having heard all of the evidence with regard to the broader conspiracy. And as we point out in our papers, and I don't mean to tell the court something it already knows, but we don't see any impediment, either under the Speedy Trial Act or Sixth Amendment, to the court setting a schedule that makes sense along those lines. It's obviously ultimately up to the court's discretion, and the Speedy Trial Act allows for the court's discretion. We believe that the court should exercise its discretion in trying the command and control group, if you will, the leaders and organizers first, because that way it will have the benefit, as I said, of having heard the entire case. And then, obviously, as we all know, once you try one case, the subsequent ones become much more efficient. The court would have ruled on a myriad number of issues that, will have arisen during the course of that trial that will arise in the following trials, but will require less time to rule upon, given the understanding of the entire case.
All right. Thank you. Calling upon counsel for Mr. Cliven Bundy, Mr. Whipple. Yes, if you'll have the microphone provided to him, please. Mr. Whipple, if I understand correctly, I had to make a chart to make sure I knew what position everyone took. Your client originally asked to be severed and individually tried. In response to the government's three-tier proposal, your proposal is that all of the defendants should be tried in a joint trial together. Alternatively, that the court be required to prove that it can't try 17 defendants in a joint trial, or alternatively, if the court determines to sever the trial, that he should go last. Does that remain your client's position?
It does.
And what is your client's rationale and your own rationale for wanting Mr. Cliven Bundy to go last?
Well, at the end of the day, my client has made it very clear that there's a tremendous hardship for all the families and the individuals that are in custody. This court only has to look into the audience to see the love from the friends and neighbors that are here supporting our clients. My client, at the end of the day, says, what is it fair? We assume that we're going to have the same result as Oregon. Why is it fair that any person stay in custody one day longer than Mr. Bundy? He's willing to go last because he believes that he's older and that he can sustain his family because he's older longer with being in custody. But at the end of the day, it comes down to the issue this court identified, and that is fairness.
So your client, as the person identified as the most culpable individual, is willing to fall on his sword, as it were, and go last in the interest of giving people an earlier day in court.
He does, and again, it comes down to fairness. He cares for these people that are around him, and he hates to see that they're away from their families.
All right. This Dow's, Mr. Ryan Bundy isn't here. He stated his position in his papers. If he changes his mind, I'll hear from him if he has anything additional to add. His position initially was that he should be tried with brothers Ammon, Mel, and Dave. In his response to the government's three-tier proposal, his position was that the court should order a joint trial for all of the same reasons that the government argued for denial of the defendant's motion to sever. And the alternative, he argues, he should go to trial with brothers Ammon, Mel, and Dave as originally requested. But his first request is that the court conduct a joint trial, again, for the reasons that the government argued against the individual motions to sever. With respect to Defendant Ammon Bundy, Mr. Hill, he originally took the position that he should be tried with brothers Brian, Mel, and Dave. His current position is that the court should either order a joint trial of all of the defendants, or alternatively, that he be tried with brothers Brian, Mel, and Dave as originally requested. And if I understand correctly, your papers say that he understood that brothers Brian and Mel were in agreement, and he was still communicating with, or the other way around, excuse me. He understood that brothers Brian and Dave were in agreement that the brothers should be tried together, but and he was still talking with counsel for Mel Bundy about that.
Correct, Your Honor.
Does that accurately represent your client's position?
That does, Your Honor.
Are there any factual arguments that you have in response to Mr. Meyer's arguments about the three-tier proposal that have not been stated in your papers?
Not stated in the papers. Just one thing I'd like to emphasize was that the grouping of the brothers, the government responded in terms of proper joinder, but in the initial papers in May, the grouping of the brothers was actually proposed as an organizational tool for the court. That was the agreement we all worked on. Of course, understanding, even setting aside the joinder rule, we worked together pretty hard in May to get that group together for purely organizational and for the ease of the court. So that has been the position since May. We worked to
I'm not sure I understand what you're saying. Are you saying that you recognize the difficulties of a 17-defendant trial and were attempting to come up with some proposal that was less cumbersome than a 17-defendant trial?
After what Your Honor had broadcast at the initial case management conference, that was what we worked to do back in May, was to arrange that group specifically just for those purposes, notwithstanding severance and joinder arguments, understanding that that was the court's position. Just the difference that we'd like to emphasize as regards the government's factual grouping, they say in their reply that they call their factual grouping, they don't call it a factual grouping, they call it a conceptual grouping. They've grouped by a concept of culpability. We would propose, again, I would be remiss if I didn't emphasize that Ammon's primary position was for a full joint trial, as well as Mr. Ryan Bundy, who joined in that motion. But in terms of the grouping of the brothers, I won't rattle off everything that's in the papers.
I'm just asking you if there are any nuanced arguments as a result of what Mr. Myrie has now argued here in open court about his claims on economies saved by the groupings the government proposes.
On the macro scale, I'll close just by saying their grouping is conceptual and ours, as laid out in the pleading papers, is factual.
And with respect to the sequencing, you did not take a position if you don't get your first choice, which is a joint trial. You did not take a position in your papers with respect to where, in the scheme of things, your client should be tried with his brothers if that's what the court orders. Do you have a position in that regard?
No, Your Honor, that would be of minor concern.
So you're telling me that your client would be okay with going last?
No, Your Honor.
Well, and that's why I'm asking you. I need to understand what your position is. You're telling me the sequencing would be of minor concern. And when I asked you if that means you would go last, you said no. So where do you want to go in the scheme of things? You want to go with the government's proposal that your client be among the ones that are tried first on the theory that he's most culpable of all of the defendants charged, or not?
Yes, Your Honor. I mean, ideally, he would like to go first. There's more in the papers, concerns that we laid out in terms of the organ timing and everything like that. It's not something...
Are you prepared to go first?
Yes, Your Honor.
All right, thank you.
Okay.
Now, Mr. Hill, and I would ask, please, Mr. Ryan Bundy is very articulate, and he's filed his own papers. He's clearly able to state his mind and to get his point across. And I would ask that you please not file papers that purport to be filed on both individuals' behalf. He filed his separate paper that creates confusion because the way he expresses his position is slightly different than you express his position on his behalf. So he's welcome to join any motion in which he has a dog in the show that you file on Ammon Bundy's request. But please, and I'd ask all counsel of you, do not file things that purport to be filed on somebody else, on behalf of somebody else's client, because I don't want any confusion about what the client's actual position is, okay? Don't fault you, I'm sure you did that for, with good intentions, but, all right. Counsel for Ryan Payne, who will be addressing Mr. Payne's position with respect to severance in this matter. Mr. Carrico?
William Carrico for Mr. Payne.
All right. So, Mr. Carrico, your client has consistently taken the position that he should be severed from the trial of all of his co-defendants, and that remains his position now. Is that correct?
That is correct, Your Honor.
And do you take a position with respect to where in the sequence of the trials, given the court has indicated a severance will be ordered, that Mr. Ryan Payne should be tried?
Mr. Payne would like to be tried first, Your Honor.
Is there any reason other than the obvious that he'd like to have a disposition before everyone else and have his day in court?
No, Your Honor, I think we've consistently asserted our...
No, that's fine. I'm truly asking if there's any other specialized reason that Mr. Payne has that every other defendant in this case doesn't have. Are you prepared to be ready for trial on February 6th on behalf of Mr. Payne?
Yes.
Thank you. Counsel for Mr. Santilli, Mr. Rasmussen.
Good morning, Your Honor.
Mr. Santilli originally took the position that he should be severed from the trial of all of his co-defendants. His papers argue that he is uniquely situated and from his co-defendants in that his defenses are different from his co-defendants because his conduct consists of words and actions protected by the First Amendment. That remains your position, correct?
Your Honor, I think after listening to the government today, Mr. Santilli, obviously in a perfect world, we'd like to all be tried together.
Well, that's not what he said at first. He said he wanted to be severed. He only wanted to be tried by himself because his defenses are unique, because he was engaging in First Amendment protected activity as a journalist, and so he should not be tried with any of the co-defendants. And then in your response to the government's papers, you now say that he still wants to be severed. That was a position you took in writing. But alternatively, if I don't give him a separate trial all by himself, he wants to be tried with all of his 16 co-defendants.
Judge, I think in a perfect world, he would want to go first and be tried alone. Obviously, we know the court's not going to do that. Listening to the government today and you're speaking about a split into 8 defendants going first, I think that Mr. Santilli would agree that that is probably the best case scenario that he can hope for with regards to the amount of people that need to be tried in this case. So we would ask this court to split it into the first 8 defendants, allow Mr. Santilli to go
When you say the first 8
forward.
defendants, we have 5 defendants in the first tier, and we have 6 defendants in the second tier.
And Judge, we have 17 defendants total. We would ask the court,
I'm trying to find out how you get your 8, because tier 1 is 5, tier 2 is 6, that's 11.
I understand that, Your Honor. We're ignoring the government's tiering system. We're not accepting
But you're not
that.
proposing another one, and that's
We're
what I'm
accepting,
asking.
just take the indictment, take the first 8 that haven't pled, and go with that, and we try those first 8, and then what happens, then the next group goes, and they finish the case in 2 trials instead of 3 trials.
Counsel for no Bundy, Mr. Lucas Gaffney. If you'll wait for the microphone, please. Your client's initial position was he should be severed and tried by himself. He now argues, in response to the government's proposal, that all 17 defendants be tried in 1 trial. Does that remain your client's position?
Yes, Your Honor.
Do you have any alternative suggestion to a joint 17-defendant trial now that the government has aired its proposal and rationale for its proposal?
No, Your Honor, we're maintaining our position. Mr. Bundy would invoke his right to a speedy trial. He wants to be tried as quickly as possible.
And are you prepared to try this case on February the 6th?
I am.
Mr. Rasmussen, I declined to ask you, or forgot to ask you, are you prepared to try this case on February the 6th?
Of course, Your Honor.
Okay. Mr. Potter, on behalf of Dave Bundy, you originally proposed in the first motion to sever that your client, that is, Ryan, Ammon, and Mel, should be tried together. In response to the government's proposal, your position is that your client should be individually tried as the first request, alternatively with brothers Ryan, Ammon, and Mel, or as a third option, only with brother Mel. Does that remain your client's position?
It is, Your Honor.
You did not take a position in your papers with respect to the sequencing of the trial, either individually or with one or more of the brothers. Do you have a position in that regard?
Your Honor, I've tried a case here in this district with 18 defendants in 1986 in the Squatro case. I know it can't be done. Our position is I wanted to stay with his brothers. The government has put us with the Arizona militia. I think we have somewhat antagonistic defenses. We also have Mr. Cavalier.
Let me stop you. You mean your client and you believe it would be adverse to your client's interest to be tried with Arizona militia members?
Yes. They were protesters that had long rifles. My client was unarmed. It was a peacemaker. We have concerns about Mr. Cavalier and his position in this case as well as in the case in Oregon. And we believe there's an invasion of the defense camp and having a tier with us.
So you believe that your client would be prejudiced with a joint trial with members of militia who were armed when your client's position and that of some of the other Bundy brothers is that they were never armed at any point during any of the events?
Yes, Your Honor.
And are you prepared to go to trial on February 6th?
Yes, ma'am.
Counsel for Mr. Cavalier, Mr. Yampowski. Your client originally took no position with respect to whether or not this case should be severed, and now asks that he be tried with Cliven, Bundy, and the other 5 Tier 1 defendants. Does that remain your client's position?
Yes, Your Honor. And if the court, depending on the sequence of the tiers, while he would prefer to be tried in the first tier, because he didn't waive his speedy trial rights, More important than that, he believes he should be tried with Cliven Bundy because the evidence is similar, and that would be his position.
And in what respect is his case consistent with the defense of Cliven Bundy's case that warrants him being included in a trial of the Tier 1 defendants?
Well, Your Honor, he wasn't at the wash, he wasn't at the bridge, he was essentially connected at the hip with Cliven Bundy, and our concern is if and I can't speak for the other defendants, but it seems like, based on the Oregon defendants and based on the joint meetings I have attended, that most, if not all, defendants will testify, and it's our position that Cliven Bundy's testimony will assist Mr. Cavalier in his defense, and if he is tried separate from Cliven Bundy, we're concerned that at that time Mr. Bundy would assert his Fifth Amendment rights. I know that hasn't been litigated, and there is essentially a split of authority, but that is our concern.
Mr. Asmussen, I'm not going to allow people to hone in. Let me get through the people who haven't been heard from yet, and don't stand up to interrupt the process. Is your client prepared for trial on February the 6th?
Yes, Your Honor.
And with respect to the sequencing, he would prefer to go first?
That's correct, Your Honor.
And you've talked to your client about the fact that if he goes with the Tier 1 defendants, there's going to be evidence of other Tier 1 defendants introduced at trial in all likelihood in which he was not involved.
Yes, Your Honor.
Counsel for Mr. Parker, Mr. Marchese.
Yes, Your Honor.
Your client's initial position was that he should be severed from the trial of his co-defendants and tried with co-defendants Parker, Drexler, and Stewart. And if I understand correctly, that's because they're all residents of the same state who traveled here together?
Correct, Your Honor.
And after the government made its three-tiered proposal, your client's proposal and position is that being tried on February 6th outweighs the desire to be severed.
That's a correct statement.
Does that mean that he's willing to go to trial with whoever goes first?
Yes, Your Honor. His initial wish to me was that he would be tried in a joint trial. However, I did not address that in my moving papers.
No, you did not.
The court was clear and explicit in the court's order that there was not going to be a joint trial. Furthermore, I would have to concede that logistically that's just not going to happen. So what we proposed was that he would go...
And why do you concede that point, Mr. Marchese?
Well, just looking in the courtroom here today...
referring to the number of people that are here, the cramped conditions, the inability to have microphones at every table and the like.
Exactly. I would imagine we're going to have multiple alternate jurors, so there just would be nowhere for everyone.
Right. We have defendants seated in the jury box. This is the largest courtroom in the district, and there are 16 seats in this in the jury box. We have the defendants and their counsel seated there, and obviously do not have room for them on the defense side of the table for all 17 individuals in the counsel.
Understood and agreed.
All right. And so your client's preference is to go first, and he's willing to go to trial with whoever is in the first-tier defendants to be severed.
That is correct.
And you're prepared to go to trial on February the 6th?
Yes, I have been working my schedule so that I will be open for February, March.
Mr. Leventhal, on behalf of Mr. Drexler, first of all, your client's initial position was that he should be severed and tried separately from all of his co-defendants. After the government made its proposal, your client's position in the papers that you filed were that he should, the government's motion to sever should be denied, and he opposes being tried with follower gunmen. You don't make a proposal, however, about where your client should be sequenced in terms of the trial and with whom your client should be tried. So let me hear from you, Mr. Leventhal, about your position in that regard.
Your Honor, I obviously came a little bit later to this. I was, I don't know what his position prior to was a prior counsel. So at this point, my client would like to be tried along with Parker and Stewart, the people that came from Idaho. And in terms of position, he'd like to go first. That's his, and I'll be ready on February. I've cleared my calendar as well. Obviously, the government has indicated he's one of the most least culpable in all this, and the evidence that would be presented for the most culpable would probably be the same for the least culpable, given that this is a conspiracy. So with that, his wish would be to go first, and to be tried with the other least culpable defendants out there.
Do you mean all 7 of the co-defendants in the so-called gunman follower group? Because that is contrary to the argument that's made in response to the government's proposal.
I'm suggesting that all of the Tier 3 defendants that have been named there, the least culpable defendants, go first, because he is in custody right now.
I understand that, but that is contrary to the position that you took in your papers.
I didn't take a position in terms of when he was going to go or what tier he was going to go into.
That's true. But your paper said your client did not want to be tried with other members of the so-called followers of gunmen, and now you're retracting that position, correct?
Correct.
And you're prepared for trial on February the 6th?
Yes, Your Honor.
Mr. Perez, on behalf of Defendant Richard Leveling.
Morning, Your Honor.
All right. Your client's initial position was that he should either be severed and tried individually or tried with co-defendants Parker, Drexler, Stewart, Engel, Burleson, McGuire, and Woods, which are all of the Tier 3 defendants, correct?
That's correct.
And his response to the government's proposal of 3 tiers is that his desire to be tried and go forward on February 6th outweighs any desire to be severed from any of his co-defendants.
That's also correct, Your Honor.
And is your client still willing to be tried with the co-defendants that he listed in his initial motion to sever?
Yes.
Are you going to be ready for a February 6, 2017 trial?
Yes, Your Honor.
Well, you're making facial expressions.
Well, Your Honor, I'm, as Your Honor is aware,
it's a big case.
I understand that, and I am prepared. I mean, as Your Honor is aware, I was here the other day with a matter that may be a potential conflict. As far as the
for the record, that potential conflict has to do with another defendant's case being set on the same day, not a conflict of interest that would...
That's correct.
All right. And there isn't a lawyer in this courtroom that has only one case, or doesn't have potential other clients' cases that may need to be moved or set aside depending on the final order report on the order and sequence of the trial in this case.
Understood, Your Honor.
All right. Everybody's under the same pressure, including the court. It's not our only case either. All right. Mr. Tanasi, on behalf of Mr. Stephen Stewart, your client's initial position was that he should be severed from all of his co-defendants and tried separately. His response to the government's proposal is that being tried on February 6, 2017 outweighs his desire to be severed. Does that remain your client's position?
Yes, Your Honor.
Is your client willing to go to trial with whatever group is set for trial in the first tier?
Yes, Your Honor.
I mean, the first group for trial, not necessarily.
That's correct, Your Honor.
So he'll go to trial. He doesn't care. He doesn't have any arguments about the severance of the trial for other reasons. As long as he goes first, that's all he cares about.
That's correct.
Counsel for Mr. Engel, Mr. George. Your client's position was initially that he should either be severed and tried individually or tried with co-defendants Parker, Drexler, Stewart, Loveling, Burleson, McGuire, and Woods. Those are the Tier 3 defendants. In response to the government's proposal, however, he has now said he doesn't want to be tried with the Tier 3 group as he initially requested, but he wants to be severed and tried individually. Does that remain your client's position?
No, Your Honor. His first choice would be to be tried with the entire group, if not to be severed individually, and if not to be tried with the Tier 3 group.
So his first choice would be he go to trial on February 6th with all 16 of his co-defendants?
Correct.
His second choice would that he be tried individually?
That's correct.
And where does he propose to be tried if he was individually severed and tried by himself?
After the first group, or at the end of the first and second, third groups. Last.
So he wants to be tried last.
Well, if he's going to be severed individually, last.
And what's the rationale for why Mr. Engel wants to be tried last?
That would be so I could prepare.
So you get to hear the case from everybody else? And Mr. Engel is shaking his head. So confer with your client, Mr. George, because it's not all clear to me that your client is in concurrence with what you just told the court.
Well, he wants to go first.
Okay, we've gone from last to first.
Yeah.
All right, so if he's tried individually, he wants to go first.
That's right.
And he wants to be in the first group, no matter what.
That's right.
And his third alternative is he would like to be tried with the co-defendants that are in Tier 3, and again, he wants to go first, correct? All right, I'm getting a thumbs up on all three counts from, individually from Mr. Engel. Mr. George, are you prepared to go to trial on February the 6th?
I will be.
Mr. Jackson, on behalf of Mr. Burleson.
The most important thing is that my client was...
Wait for them, oh, you have it, okay. Let me first and foremost, he took the position that he should be tried individually when he initially filed a motion to sever.
That's correct.
He now took no position with, in response to the government's proposal. So now tell me what your client's position is.
He takes no position against the government's proposal. But he does not want to go last. I discussed with him several times in the jail about the advantages of going first to last. Today he wants to go first because he doesn't want to wait until August. He has many medical conditions that adversely affect him. I have advised him as his counsel that going first is not to his advantage, and because I think that it doesn't make any sense for one of the people that is the least culpable to go first. It's still my advice as his attorney that he not go first.
All right, and so, Mr. Jackson, what you're just telling what almost every criminal defense lawyer knows is that everybody would like to see the government's case first before you try your part.
Yes, and that's my advice to him. It's also, I think...
But it's his call about what position he's taking, correct?
What? I do not oppose the government's structuring here that he go last. If he can't go last, I think he should go second, at least after the Bundy family goes. Because he should go at least after the Bundy family goes. In fact, his terror court chooses.
Mr. Burleson, do you understand that your lawyer is giving you advice that's contrary to the position that you want to take? All right, so your first choice is that you be tried with everyone.
And I want the record to reflect, I think the only reason he wants to go first is because of his extreme medical conditions. And I have advised him that I will seek another motion for release. I've taken that up to the Ninth Circuit. He is suffering from very medical conditions that I've made record of. I think he either manipulated into this or because of his medical status, he's in a wheelchair, he's completely fine, and he has diabetes and other medical conditions.
So, Mr. Burleson, essentially you're saying the equities weigh in favor of you being in the first group because of your current situation and medical condition. Is that right?
No, I think that...
I'm addressing Mr. Burleson right now because
Mr. Burleson wants, because of speech trials.
Yes, is that true, Mr. Burleson? You want to go in the first group because you're...
Unless he can get out of custody or he gets some kind of...
Sure, and then he doesn't care if he ever goes to trial.
He'll still have to go to trial and do what he needs.
All right. You don't want to wait. All right, sir.
He doesn't want to go to trial and get convicted.
I understand, and you're at odds with that. It's a strategic decision that your client has, or a strategic position that the attorney to take about what's in your best interest, which deviates from what Mr. Burleson himself wants.
But I don't think one of the decisions that the defendant can make is to go first. You have to make more decisions.
I understand that, Mr. Jackson. I'm just now clarifying what your advice is and what his desire is. All right. That happens all the time, sir, but there are decisions that are absolutely up to you as a client, and there are decisions that a lawyer gets to make on your behalf. Ultimately, the ruling on the motion to sever is going to be up to the court. So I just want to make sure that I understand what you have to say and what your lawyer has to say.
One last thing I'd like to say is I think he's being manipulated by other defendants in this case, which I think is wrong.
You're welcome to put that in writing and tell me what, if any, relief you're requesting from the court as a result. Ms. Loom, on behalf of Mr. O'Shaughnessy, you originally filed papers on Mr. O'Shaughnessy's behalf indicating that he wanted to be tried individually, and your response to the government's proposal of 3 tiers is that Mr. O'Shaughnessy's desire to be tried on February 6 outweighs any desire to be severed. Does that remain your client's position? And is your client willing to be tried with whatever group is tried first, as long as he goes first on February 6th?
Yes.
Are you ready for trial?
Yes.
Counsel for Mr. McGuire, Mr. Arabia, your client's initial position in this case was that he should be severed and tried individually. His response to the government's proposal is that he be tried on February 6, 2017, and his desire to be tried first outweighs his desire to be severed. Does that remain your client's position?
Yes, that's correct, Your Honor.
Is he willing to be tried with any group of defendants as long as he's tried first?
Yes, Your Honor.
Are you ready for trial on February 6th?
Yes, Your Honor.
Counsel for Mr. Woods, Ms. Kazemka, your client originally filed papers on his behalf. You filed them indicating he should be severed and tried individually. You filed a response to the government's proposal indicating that your client's desire to go to trial on February 6th outweighs his desire to be severed from his co-defendants. Does that remain your client's position?
Amended just slightly, Your Honor. His first choice would be to be severed. He was originally in Tier 3. He is now in Tier 2. So in the court's suggestion in bifurcating them into 2 groups, he would prefer to be in Tier 3 and go first. His second or alternative option would be to go with Tier 1 or whoever else is going on February 6th. Your Honor, if I can add something.
Just let me make sure I understand.
Okay.
He first said that he wanted an individual trial. He's now saying he doesn't care who he goes to trial with as long as he goes first with the first group.
No. He would like to go first with the Tier 3 group.
All right. And his second alternative, so he doesn't want to go to trial first if he is lumped in with the Tier 1 group.
He wants to go to trial first.
I get that, but
yeah,
and so I ask you, does he want to go trial first no matter who he goes to trial with? And the answer is...
Sorry.
But his preference would be to go to trial first with the Tier 3 person?
Yes.
All right. Are you ready for trial?
Yes, Your Honor, I am ready for trial.
And you wanted to add for the record?
The government, on multiple occasions this morning, referred to the people in Tier 3 and 2 others in Tier 2 as gunmen approximately 8 to 10 times. In the moving papers, the leaders and mid-level people are designated as such. Gunman carries with it a heavy connotation of guilt or culpability, and we've been talking about, well, if you're in the first tier, you're more culpable than in the third tier. But the designation...
Only insofar as the government's argument about the sequencing and their characterization. I'm not adopting that. I ask questions based on the government's own characterization of who is most and who is least culpable in their own proposal. So I understand you don't go along with that.
Right, and certainly I will file something with the court asking that some other designation be given, such as least culpable or demonstrators, as opposed to
What is being argued in pretrial motion and what's going to be permitted before the jury may be 2 separate things. Right. And you know that, and you know motions in limine are the appropriate device to raise issues such as this before trial. All right.
Thank you, Your Honor.
All right. I will give the government 2 minutes to respond. Now that you know the positions taken by the individual defendants in response to the government's 3-tier proposal. Do you have anything that you want to add to what you've already told me, Mr. Miley, or what is in your papers?
Just a couple of quick points with response to Defendant Woods. I believe in our papers we've been consistent that he'd be in Tier 2. The Tier 2, O'Shaughnessy, Woods, and McGuire are linked by their affiliation with the ASM and came up to Bundy Ranch as a group. With that said, the only other thing I would add, Your Honor, is that you made different references, and you asked the question earlier about 2 versus 3 groups. It's our position that 2 groups, we're not going to gain any efficiencies through severance, other than we'll have a smaller number of people. But again, we don't see how this breaks into 2 groups where we don't have evidence that's going to be presented, whether it be more limiting instructions required, more evidence coming in that the jury is going to have to sift through. It makes it more complicated for the jury to conceptually understand, as well as to understand as the evidence is coming in. So again, we would say that 2 groupings, obviously it's in the court's discretion, but 2 groupings isn't going to save us much.
You prefer your proposal because it's consistent with how you believe you will be presenting evidence at trial.
That's correct, Your Honor. And it reduces the number of limiting instructions, I guess. That's what I'm concerned about. We don't want, while spillover occurs in any joint trial, we want to minimize the spillover as much as possible, even though it can be cured, as the court knows, with the limiting instruction. We want to minimize that as much as possible, which is why we advocate for 3 versus 2 tiers.
All right. The next motion that is set for oral argument is Mr. Payne's motion to strike surplusage, docket number 718. And you're basically arguing that certain language that is used in the superseding indictment is inflammatory and improperly uses code words to characterize the conduct of the defendants. Is there anything that you believe, and also you're asking to strike some of the headings of the superseding indictment in which the government breaks down its theory of the case in terms of sequencing of the events? Is there anything that you wish to add to your papers that are based on developments in this case since the motion was filed? And who will be addressing Mr. Payne's position in this regard?
I'll address it, Your Honor.
And I'm sorry, it's a sea of faces out there. Is that Mr. Norwood?
Yes, it is, Your Honor.
All right. You're near a microphone, so yes.
You know, this is a very unusual indictment. It's over 60 pages long. It certainly doesn't need to be that long. I mean, by contrast, the court's
But yet certain defendants say it should be longer because the allegations are insufficient to put them on notice of what their participation or involvement of the charges are. So you don't agree with that? You think it's too long?
The issue is not even just the length, it's the content. It reads like an opening statement. And, you know, the government will get a chance to make its opening statement at trial, just as we will get a chance to make our opening statement. And just, you know, we have different lawyers in different parts of the courtroom here, but part of the reason why it's important for Mr. Payne to be tried first is not just the fact that he's in custody, but the fact that, you know, we have not yet had the opportunity to tell our side of the story. But, you know, that's what opening statements are for.
So let me just stop you and ask you there, because it's usually a cardinal principle that defense lawyers rely upon, is that the government overpromises its case either in charging a document or in an opening statement, usually in order to the defendants to benefit. Does it not?
Well, it can, but the fact is by putting, you know, what we believe to be prejudicial, inflammatory, and irrelevant information in an opening statement creates problems in and of its own. So, if the government does that in an opening statement, we can obviously deal with it in an objection. It seems like what they're trying to do here is, first of all, have an opportunity to have a judge read their opening statement by reading the indictment. Second of all, to have their opening statement sent
You're
back to
concerned
the
about
jury.
the imprimatur of the court being attached to the indictment. But the government points out, and of course this is an instruction that's given in every case, and typically at the beginning and at the end, a charging document is just that. It's not evidence, and you're not to consider a charging document as evidence. It's what the government hopes to prove in the case.
Well, you can say that about anything, but that doesn't necessarily solve the problem of
You still
unfair
believe the
prejudice
language
when
is
they
too
hear it.
inflammatory and prejudicial?
Right. I mean, if there's something to be said, it can be dealt with in their opening statement and their closing statement, but there's no reason why the jury should see most of this irrelevant narrative. We're asking it to be stricken because that's the remedy suggested by the rules of criminal procedure.
Or in the alternative, that it not be provided or read to the jury in its entirety?
Correct.
Does the government intend to ask the court to read this 64-page superseding indictment to the jury in its entirety?
Not yet, Madam Assistant United States, Your Honor. Your Honor, it was not the government's intention to ask the court to read to the jury the full indictment prior to being no trial.
And is the government going to ask, for example, that the indictment be presented to the jury in any other format in trial?
Your Honor, we would likely ask it to go back with the jury for purposes of allowing them to see the charges that have been placed before them.
Isn't that what jury instructions are for?
Your Honor, there's that as well.
I mean, they're going to be getting a jury instruction for each and every charge with which they're accused. Why isn't a jury instruction adequate enough to inform the jury of the findings that they need to make in order to make a decision on whether the government's proved its case beyond a reasonable doubt?
Your Honor, at the end of the day, of course, this would be a decision for the district court to make, but our preference would be that this indictment would go back to the jury simply because there is historical information which, although defense counsel asserts without anything supporting it that this is irrelevant or prejudicial or inflammatory, these
Aren't you
actually...
basically asking that the entirety of the superseding indictment be given to the jury, even though they're instructed that it's not evidence and can't be used as evidence?
Simply, Your Honor, because as we've indicated in our papers, it is a roadmap as to the background of the case. At the end of the day, Your Honor, of course, we would defer to the district court's ruling on that issue.
Thank you. Turning to the next motion on the docket, this is the motion that has been filed by counsel for Ryan Payne, requesting a transfer of the jury trial in this case to a different venue.
Your Honor, I'm sorry, Attorney Thayer is going to address that motion.
Your Honor, this is Thayer to Mr. Payne. I don't want to reiterate everything in the motion for the court's instructions, but I would like to highlight that this case is unique, very unique. A unique factor that supports venue that's not present in any other case that I've read is that a political campaign for District 1, which contains Bunkerville, a congressional candidate used the Bunkerville protest to win a congressional election. It was in his flyers, and it was in the flyers sent by the Democratic Party. And that's an exceedingly prejudicial factor that's present here that's not present in other cases. It shows that the Las Vegas community has been tainted. And that shows that Mr. Payne cannot receive a fair trial in this venue. And we would request that the court move the trial to another district, or at the very least, pull the jury from the Reno jury pool.
Well, you asked for any other district in the Ninth Circuit that goes from Alaska to Hawaii and all of the states in between. You're telling me your client would be comfortable, for example, with a trial in Oakland?
Well, Your Honor, we would request that if the court is inclined to grant this motion, first the court must make the inquiry whether this community has been
Saturated with fake publicity.
Yes, with inflammatory news coverage and...
Why isn't this a matter that is best addressed at voir dire to determine whether or not members of the panel who are actually summoned to come to court have actual bias that they, because, the test is not whether or not the members of the community and members of the veneer, that is the jury pool, have been exposed to prejudicial pretrial publicity, but whether or not they can render a fair verdict.
Your Honor, because there are two types of prejudice that can require moving a jury to a different venue. There is the presumed prejudice analysis, which is what's raised in a motion, and that is entirely separate from the actual prejudice that can be established.
Right. Your argument is the saturation of the local market alone is sufficient to warrant severance because the prejudicial pretrial publicity is so poor that your client can't get a fair trial.
Yes, Your Honor. Yes, and that's the presumed prejudice analysis. It's presumed because of the nature of the coverage, and here we also add the campaign.
How, if at all, would severance of the trial affect your argument?
Well, yes, Your Honor, we've requested a separate trial. And
I understand that.
A separate trial would occur in Reno, at the Reno courthouse.
I understand, but the most inflammatory coverage that you mention that your client is concerned about is, one, the flyers and the video campaign ad that showed statements made by Defendant Cliven Bundy, correct?
Yes, but the flyers also, prejudicially and without proof, connected the Bunkerville protest to the shootings of two Metro officers in June of 2014. That is something that is a connection that has been made by the media and the campaign. That can't be undone.
That was coverage that said that Jared and Amanda Miller had been out at the Bundy Ranch at some point during the encounters with the agents that bring us here to court today.
That's what the news reported.
And when's the last article that has been in the news about the Millers and their connection to the Bunkerville protests?
The last article, I'd have to reference on motion, I apologize, Your Honor, but I would reference that the campaign, which occurred, the election just occurred in November.
How many members are in?
Those flyers referenced that.
All right. How many people did those flyers go out to in Congressional District 1?
We don't know that, Your Honor. That's what the campaign, they have that information. We couldn't obtain it. But we know that we were able to easily collect those flyers that we included in.
No, I understand you have them. The question is, in a congressional district, no political candidate that I know of sends flyers to anybody other than potential voters in his or her district. And so I was asking about how big of a district that was for purposes of seeing who was potentially exposed to that publicity.
It is Congressional District 1, Your Honor, and I could provide the statistics on the population for that Congressional District where it covers. I apologize for not having that information.
Do you really dispute that the jury pool in Las Vegas in the unofficial Southern Division for this district is substantially larger than the other two divisions in this district, one in Reno and one in Elko?
It's substantially larger, I believe, in population, yes.
And in jury pool, correct?
Yes, sir.
And in the available jury pool?
Yes, that's what the statistics indicate, although we are still requesting information from the clerk of the court.
And you also understand that from the information the court compiles that the jury panel in Las Vegas is substantially more diverse than the jury panel that would be available in the unofficial Reno Division and Elko Division, correct?
I don't believe that the government has presented any proof of that.
Have you looked at our...
something that's of common knowledge.
All right, so you just don't know.
We don't know, and it also is not, that is not what's necessarily controlling or as relevant for the venue motion based on the inflammatory coverage, which our reply brief attached those reports, as extensive reports showing the media coverage in Las Vegas versus Reno. It's not comparable.
And how, if at all, is the coverage of your client's acquittal in Oregon affecting the analysis?
The Las Vegas Press has covered that. They have a specific article on Mr. Payne pleading guilty in Oregon. And everything that happens in Oregon gets reported in Las Vegas, almost as much as what happens in this courtroom about this case. And we've shown that in the motion, supplemented in the reply, and we continue to supplement. This is an issue that can be live until we switch over to actual prejudice at the jury arena. There's no indication that coverage will lessen. It will probably ramp up given what's happened.
Although your
before.
papers say the peaks in the coverage were in April of 2014 and February of 2016, correct?
Yes, yes. During the actual protest was the highest level of, but there has been substantial peaks during the important court proceedings.
Thank you. So you asked first that for the relief of the transfer of venue, but if the court doesn't grant a transfer of venue at this time, that you have leave to revisit the issue when a jury panel is brought in so that it can be questioned and determine whether your client can get a fair trial.
Yes, we will absolutely renew, if this court denies the motion about presumed prejudice, we will renew the motion when the actual prejudice can be demonstrated during the court hearing.
Thank you. And with respect to the government's position in this case, do you have any intention whatsoever to try to link the murder of the two Metro officers and a bystander by Jared and Amanda Miller to the defendants in this case?
And Cliven for the United States, Your Honor, no, we do not. And does the government have anything to add to its papers concerning the position taken that the jury pool in this case is sufficiently large and diverse that the court should wait until we see what people have to say when they're examined? Only to add, Your Honor, that in scaling of the Supreme Court's most recent rumination on change of venue, there were 4,000 media articles about the CEO of Enron, and the Supreme Court still found that change of venue was not necessary because Houston was a large enough city that 12 impartial jurors could be drawn.
And what's the population of Houston compared to Las Vegas?
The population of Houston it's the fourth largest city in the United States. Las Vegas is the 30th. But this is similar to other cases with any populous city, which includes the Charles Manson murder, the Watergate case in D.C., which is a comparable population of about 3 million at the time, as well as the Boston bombing, which is a population of about 3 million in the Boston area, that cities which number in the millions can produce an impartial juror panel of 12 people.
Thank you.
Your Honor, I joined that motion and I have something to say about it.
Mr. Rasmussen, when you file a one-line joiner that just says what he said, you don't get oral argument.
I filed more than a one-line joiner. I filed a joiner with attachments with the direct mailings.
Very well. Go ahead.
And Judge, I think it's much different than the cases she's talking about. The Enron case, this case involves direct mailings where actual potential jurors are receiving these nasty postcards about Cliven, Bundy, and the Millers. It's different than pretrial publicity. That's usually the cases that we see. I can't find one case anywhere in any part of the country that deals with a change of venue that involves direct mailers where the jurors actually saw it and had it sent to their mailbox. District 1 goes across from Russell to Lake Mead, across the belly of our city, and that's where we're pulling the jury from. And I know a lot of we've heard stories already that a number of summons have went out to prospective jurors. We had no indication of where they were pulling from. And I know up in the Oregon case, Judge Brown made an exception and she pulled from the entire state of Oregon and allowed the entire state to participate in the jury. And I think that's what we're asking for, is allow everybody in the state to come down and be part of the panel, at least have the prospect of being part of the panel, and then we can determine if we can get a fair jury. By just taking the belly of the city, we're going to have these people in here, they got these direct mailers, and we're going to be sitting in trial with people that have heard these horrible things about Mr. Bundy. And I just think that it's a problem that we need to address now.
Do any of the mailers in the pretrial publicity that address Mr. Bundy's link Mr. Bundy to your client?
Judge, obviously, they're alleging a conspiracy.
I understand that, but I'm now asking you a more specific question, which is, do any of the direct mailers that you argue are the most inflammatory that were sent out to members of District 1 or voters in District 1 link your client with Mr. Cliven Bundy's statements that are the ones that are the most potentially inflammatory?
I believe so. I believe that his statements about race relations will affect the jury pool that we get in here, and it'll directly...
That wasn't my question. Did any of the mailers that were sent out that you're talking about name your client or reference your client in connection with the events at the Bundy Ranch that lead us here today?
Of course not.
All right, and that's what I thought, but it's the association with Mr. Bundy who did that you're concerned about.
It's a huge concern. It's going to be a cloud over the pool that we see in here, and I don't think how we're going to get around it the day of jury selection. We should head it off now and re-pool from the entire state so we have a better...
Even if that means delaying the trial because we can't get a sufficient pool in that time?
We're not agreeing to waive the speedy trial, and I think there's enough time to re-send out notices to get a jury in here that's going to be fair.
All right, thank you. Moving to the motion to dismiss that was filed by Ryan Payne and Mr. Santilli that has to do with the 924C counts and whether they are, in light of the ongoing development of the law in this area from the Supreme Court and the Ninth Circuit. Let me hear first from counsel for Payne on your arguments in that regard.
Ryan Norwood. Again, this is the crime of violence issue that pops up in lots of other contexts in federal criminal law. And the thing that the Ninth Circuit and the Supreme Court have stressed over and over again is that this is a categorical inquiry. It has nothing to do with the facts alleged in this case. It doesn't even have anything to do with the indictment. It's what the statutory elements of these crimes are. There are two different ways under the statute that you can qualify the so-called...
And which statute are we talking about for the record? Because we all know that crimes of violence are defined for purposes of at least three different federal statutes, one under the Young Career Criminal Act, one under 924C, and one under the Immigration and Naturalization Act. So which statute are you referring to for purposes of your argument?
924C. That's what I'm always referring to unless I say otherwise. But it's structured, all of these statutes are very similar. I mean, there's basically two parts to them. There's what's called the force clause, which requires the actual attempted or threatened use of physical force, which the Supreme Court says means violent force. And then there's the residual clause, under which a court was supposed to assess whether there is a significant risk of physical force being used. The first point I would make is that the residual clause of 924C isn't any good. That's the only interpretation of DiMaia versus Lynch. DiMaia versus Lynch, we agree, is still good law.
Yeah, the Supreme Court has accepted certiorari to resolve a conflict in the circuits, but it's controlling Ninth Circuit authority on this court.
Correct.
And DiMaia was a case that involved a 924C count, or it was a case that involved application of another provision of law?
It involved the immigration statute, which reads, it is exactly the same as all material, in all material respects as the residual clause with 924C. That was in an immigration context, but if vagueness applies in an immigration context, then it has to apply in the criminal context, which is the core concern of the vagueness doctrine. And every district court in this circuit that's considered DiMaia has agreed that DiMaia means that the residual clause of 924C is unconstitutionally vague.
Yes, and so take it to the next step then. There is still, however, controlling Ninth Circuit authority that addresses whether or not certain of the crimes that are charged in the superseding indictment are crimes of violence in the Ninth Circuit, correct?
The only one where that's true is the assault charge, the 115 charge. There is a case from 2009 that held that the felony assault was a divisible charge that could be a crime of violence. This was decided before Johnson 2, so it says under either the force or the residual clause. And we addressed that in the motion in the reply. That basically that case predates both Johnson 1 and Johnson 2.
Although it hasn't been specifically abrogated, nor has the Ninth Circuit and DiMaia indicated that it would be.
No, I mean, DiMaia didn't deal with that issue specifically.
In fact, didn't DiMaia expressly state that we're making a ruling as a matter of our immigration statute, and we are not passing upon the constitutionality of the residual clause in other statutes?
What it said was that DiMaia wasn't going to decide whether there might be other civil contexts where it may not apply. But I don't think there's any principled argument to say that if this vagueness concern applies in the civil immigration context, that it wouldn't apply in a criminal context. In fact,
It compels the result in this case, is what you're saying, is that the offenses charged in the superseding indictment are not crimes of violence after Johnson and after DeMaia.
right, well, I mean, we sort of went into the specific issue with the felony assault, and I agree, you know, that there is a case, juvenile female from 2009, that says that satisfies the force clause, but the problem is, this is an area of the law where, you know, it's fast changing, and since then there have been at least 2 important cases decided by the Supreme Court that further clarify what a crime of violence can't be, and that juvenile female can't be considered good law after those cases. But we acknowledge it's still there, and it hasn't specifically been overruled.
And
with regards,
go ahead. Does the defense have any updated information about when DeMaia will be decided by the Supreme Court, if it's set for this current term for decision?
so right now it's in the middle of briefing. It was just set for oral argument on January the 17th. So I don't think that there's any real chance that there's going to be a dispositive decision. If there is a decision, you know, before, you know, our first trial is set to start. And it may not be, again, if there is a decision, you know, until the summer, when the term ends. You know,
Supreme Court's term ends June 30th, and so theoretically they could decide at any time between January 17th and June 30th of 2017.
Correct, and this is going to be one of the later cases that's heard in the term. You know, another problem is we don't know that it's going to resolve the issue. I mean, in the government's briefing, the primary argument they're raising there is not, you know, whether the language is distinguishable for vagueness terms, but again, this issue of whether the vagueness context should be applied to the civil immigration context. So even if the Supreme Court agreed with that, you know, that's not going to resolve the issue here. It's going to be...
Well, what was the question that they accepted for certiorari?
2 questions. Question number 1 was, you know, the argument of whether or not vagueness applied in the immigration context in the way it does the criminal context, as is the case with ACCA here. And then second was whether the language in that residual clause was distinguishable from the language in the ACCA residual clause.
But the language is slightly different.
It's slightly different. I mean, I can go through Johnson and my point that should make any difference.
Your papers have, yes, and I just want to make sure that I got the gist of what you have to say here.
So, you know, there are 3 other, you know, offenses here that there isn't Ninth Circuit authority on. I point out that, you know, for 2 of these offenses, you know, the 18372 conspiracy to impede offense and the 115 threat to assault offense, the government, you know, in its papers isn't really even trying to argue that they satisfy the force clause. You know, they're relying on the residual clause. You know, the residual clause shouldn't matter, but frankly, even if you look at that, it's very hard to make out a case. You know, what you have to do with any of these crimes is you're supposed to figure out what the idealized ordinary case is. And for statutes like these that involve crimes that are very infrequently prosecuted, and that tend to involve unusual situations, there really isn't any such thing as an idealized ordinary case. To the extent that there are cases, you know, the cases that I cite and discuss in my pleadings, even the cases the government cites, those cases tend to show that these offenses do not necessarily or even usually involve the, you know, the threatened or actual use of physical violent force. And that's especially true of the Hobbs Act extortion offense. I mean, Hobbs Act extortion, if you look through, you know, the federal quarters, it seems that most of the time the government prosecutes it. What it's prosecuting is basically bribery or kickbacks, which are offenses that, you know, may qualify under the color of law provision of the statute, but that certainly don't necessarily or even usually involve any sort of force or violence. So if it came to it, I don't think that these offenses would satisfy either prong of the inquiry, but they certainly don't satisfy the fourth prong.
And the residual clause is no longer constitutional in light of Johnson and DeMaia, is what you argue.
Under DeMaia, the residual clause is unconstitutionally vague. So I don't think the court even needs to reach that issue, but if it did, it could still say that these offenses don't meet the residual clause.
All right. and I interrupted you by asking you questions. Have you had an opportunity to state your position as you've already done in your papers?
I believe so, but I'm always happy to answer more questions.
Counsel for the government, let me hear from you concerning the 924C. Hasn't the landscape changed since Johnson and DeMaia? Who will be addressing the government's position?
I will, Your Honor. Nicholas Dickinson from the United States. As the government set out sort of quite thoroughly in our briefing, the government DeMaia does not directly affect the 924C residual clause. We realize it's the same language. We realize what, district courts have ruled that it does in the Ninth Circuit.
So the court shouldn't see the handwriting on the wall?
We don't agree that courts should see the handwriting on the wall. DeMaia was a 2-1 decision. DeMaia itself, as the court has pointed out, says we're limiting this to the immigration context because that's just murky. We're dealing with these state statutes just like the ACCA. It was a 2-1, I think I mentioned a 2-1 decision, and now it's on cert with the Supreme Court. So it is still binding law if we have a factual situation with 16B in an immigration context. The fact that it's cert has been granted did not help us here today before Your Honor. But the fact remains, the court would have to take, it's not bound by DeMaia to find the residual clause unconstitutional. For all the reasons we set forth in our brief, the court would have to take an extra step. And as far as, and I think unless the court has any additional questions, I think we thoroughly set forth the government's position about how we distinguish that in our briefing, as well as the Second, Eighth, and Sixth Circuit rely-on cases. I would like to point out that the Sixth Circuit has, on one hand, held the 924C residual clause constitutional, and on the other hand, held that the 16B went along with the DeMaia approach in that context. 16B
is the provision that defines a crime of violence under the 924C count, right?
It's the same language, but in the context of the immigration, the same fact pattern as DeMaia, the Sixth Circuit has found that was vague, but in the 924C context of that residual clause found it was not vague. So what the government asking is perfectly, legally logical. As far as the specifics, I'll start with the easiest one, Your Honor. 111B, juvenile female controls. 111B is categorically a crime of violence. It's use of a firearm or inflict bodily injury. In the papers of Mr. Payne, the deadly weapon could be, a million things. Deadly weapon is defined in the jury instruction 8.4. Dangerous weapons used in a way that is capable of causing death or serious bodily injury. It's not overbroad. Inflict bodily injury causes infliction. They make the argument that somehow this could be sort of a not direct injury caused by a person. That argument's foreclosed, as I believe the Northern District of California decision in Bell, which is a published decision, talks about how that's been foreclosed by the United States Court in Castleman, which discusses that poisoning somebody is still a use of force, because you can take that to its logical conclusion, which would be shooting a gun. It's actually the bullet that's causing the force, and pulling the trigger is indirect force, and the court's not taking it for that route. So I think juvenile female is still good law. 111B is under the force clause, even if the court were to find the residual clause is vague, is a crime of violence. The government, on the 372, the government concedes that the force clause, the court would have a difficult time finding that it would fall under the force clause, and the government would need the court to uphold the residual clause to find 372 as a crime of violence under the residual clause. The examples, you sort of think of now we're actually the ordinary case, and 372 has been used, and just going off the examples that Mr. Payne puts, the Fulbright case he cites, he says it's bogus documents to the bankruptcy judge. When you actually look at the underlying case, it's accusing the bankruptcy judge of treason, which we know carries the penalty of death, and threatening to arrest the judge. And then we go down to Finn, which is citizens arresting a federal prosecutor. Hall, conspiracy to arrest an undercover officer. I think by any means that would involve a substantial risk that force could be used, or may be used, in the course of committing the offense.
Of course, in the Ninth Circuit, legal and factual impossibility is not a defense to a conspiracy. So you can be convicted of a conspiracy even though it was factually or legally impossible for you to commit the underlying offenses.
Correct, but that still doesn't eliminate the fact that it may be used. And that's why the courts have found, for example, conspiracy to commit Hobbs robbery is a crime of violence under the residual clause.
And the question is whether the residual clause in 924C is constitutional in light of developments in the law.
Correct. The 372 count rests on that, Your Honor, and we concede that. Hobbs extortion, the government believes, well, first off, 1591 is a divisible statute. Every court, including Judge Navarro in the Abdul Howard case, which is an unpublished Ninth Circuit case, has found that Hobbs robbery is a crime of violence. Thus, the 1591 rubric is a divisible statute. The government believes that once you get down to the definition of an extortion, which the relevant language is force, violence, comma, or fear, force, comma, violence, comma, or fear, or under color of law, that the extortion definition is divisible, and that under color of law is a separate element. It's a separate way, it's a separate completely way to prove extortion that's separate, and I think that's logically... It's
an element and not a means.
It's an element and not a means, yes, Your Honor. The Ninth Circuit was using that before Mathis. The circuit split, the Ninth Circuit was on the side that Mathis said courts need to follow, so it really didn't, Mathis did not affect the law in the Ninth Circuit, it was already the practice of the Ninth Circuit. But that the color of law portion is separate, that's supported by, if the court agrees that you can apply the modified categorical approach, then you can look at things. You can look at jury instructions. The Ninth Circuit has a separate jury instruction. It's quite different than the jury instruction on Hobbs Act extortion or attempted extortion by force, which is 8.142 versus 8.143. And I think as the public defender points out, extortion traditionally in common law was the sort of color of right. The extortion by force was developed by case law. 1591 to be specific, back when the court, in the old ACCA case, ended up using, I believe we cite this in our brief, using 1591 as sort of the generic definition of what extortion is under the Armed Criminal Career Act. So I think, we're not operating, and one way that distinguishes 924C residual clause from the others is we're operating with federal statutes that the federal courts interpret every day, and we need to view that under federal law. And I think under federal law, especially the way it's applied, is that the color of right is a separate crime, a separate element, and the court can view it that way. Finally, on the threat, the 115A, I would just like to address something that the defendant had in their brief. We charge 115A1B, which is the threat to assault. It's also kidnap or murder. We just alleged the assault. 115A is the actual assault or kidnap. When you go to the penalty statute, if the assault involved physical contact, which is subsection B1, apologize, Your Honor.
The offense is an assault, the penalties depend on whether or not force was used.
Correct. So in that way, it's divisible, and if they make the point that a threatened simple assault could meet 115A1B, the government would respectfully disagree with Mr. Payne. A simple assault would carry a 1-year penalty, an actual assault under A1A, and a threat to simple assault would carry a 6-year penalty under subsection 4. That's not how the court would read that. So assault in 115A1B has to mean more. It's also a threat. That's a traditional threat statute, which courts have to interpret once again under federal law under the umbrella of the First Amendment, as we've seen in other briefing in this case. So a threat to touch somebody on the arm, I think it's Johnson 2 that says, touching somebody on the arm is not enough force, but a slap in the face is. Touching somebody on the arm is not going to meet the Ninth Circuit and Supreme Court's rubric of what meets a true threat.
What my torts professor used to call the hurly-burly of everyday life. You get jostled sometimes.
Whether it be a Bagdasarian or Alonis, it's not going to happen. So assault there has to mean something more. At the very least, a slap in the face. And on that reason, we believe the court can find that 115A1B actually does fall under the force clause and is a crime of violence standing alone. And that would not be inconsistent with other statutes. The California threat statute, I believe it's 422, although it does have language that's more than assault, it is a threat statute that the court has found categorically as a crime of violence.
Your Honor?
Yes, sir.
The government's making some new arguments here.
This is Mr. Norwood for the record.
Yes,
It's your motion, so you get the final word in rebuttal.
Okay. If I understand them, they're now saying that the under color of law means that committing extortion is in fact a divisible offense for purposes of the categorical analysis, which is the first time they've...
Yes, they're arguing, I think, that color of law is the means by which, or excuse me, is an element of the offense, one way, but not a way in which the offense can be committed. In other words, it's assault plus color of law would have to be proved.
The element would be that you have to commit the offense by one of four listed means, by threat.
I understand that's clearly your position, that they're all elements.
So they seem to be saying, though, that it's sort of a separate element that you can separate out from the rest of this. It's basically a divisible offense.
Correct. That's
I'm not aware of any court that's ever held that. The courts that have addressed the matter of divisibility of the Hobbs Act, including this court in the Smith case, have agreed that there are some divisible offenses there. I mean, the robbery is divisible from the extortion, and the attempt and the conspiracy to commit those offenses is different from substantive offense, but not that the extortion itself is further subdivided into other offenses. I think under color of law is an alternate means of extortion, but under the statute it's equally extortion whether you do it under color of law or by one of the other three listed means. So I don't think that there's anything to that argument. The other point they're making here is regarding the threat statute. I mean, the bottom line, and this is a problem with, it's almost equally the problem with the conspiracy to impede charge, that they concede wouldn't satisfy the force clause, which is just because something requires force or threat doesn't mean that it necessarily requires the physical force or the threat of physical force that is required by the force clause. In fact, if you look at, and part of the problem here is that this is not a frequently prosecuted crime, but even if you look at the examples, that are recorded in the case law, they are things that do not necessarily involve the use of physical force. In fact, there are decisions saying that, the force that's necessary to satisfy this offense doesn't even necessarily have to be communicated to the target. So, this is, I think, another example of a federal statute that the courts have interpreted broadly, but it's that very broad interpretation that takes it, that means that
led to the unconstitutionally vague determination in Johnson and DeMeyer.
Correct.
All right, turning now, please, to Mr. Santilli's motion to dismiss the indictment on grounds his conduct is constitutionally protected. Mr. Rasmussen? All right, that's a reasonable request. Can we take Marshall, how long is it going to reasonably take? Is there anyone else among the defendants who need to use the facilities? I'm saying 2 hands, 3 hands, 4 hands. All right. Let's be at ease for 10 minutes. Is that enough time, Marshals, to accommodate bathroom break? 15 it is. All right. The court is in recess for 15 minutes, and we'll be back.
You need to show a prison tattoo? No. Do any guys in there do that? Actually, we don't have the hair cutters for a week because they took them over. So now you have to ask for permission to have it. It's like living in I used to work. He's doing it.
Ladies and gentlemen, that is a 15-minute recess completed. If all parties are ready to proceed, we can continue these proceedings. Just as a reminder, if you have turned your cell phone on during that recess, please make sure they are now powered down and put away. Thank you very much. All rise.
Go back on the record. Please be seated. The record will reflect the presence of all defendants except Ryan and Ammon Bundy.
There's one lawyer, I think, John George. I don't see him here.
Smoke on you?
I don't know where.
Sir, did your lawyer, Mr. George, tell you that he was not retiring? And, all right, first of all, let's identify who's talking for the record. Mr. Engel just responded. He's Mr. George's client, and Mr. Jackson, you are indicating that Mr. George has a conflict and needed to appear elsewhere?
That's what he advised me. He asked me to fill him in on what happened. I told him I would.
All right.
Mr. Campbell, do you agree to that? Do you agree to that?
The next matter on calendar was Mr. Santilli's motion to dismiss based on arguments that his conduct is protected under the First Amendment. Mr. Rasmussen?
Thank you, Your Honor. If I may stay seated.
You may.
Judge, I know you don't want me to go through my moving papers line by line. I think I laid it out pretty clearly, paragraph by paragraph of the indictment where the government alleges unlawful First Amendment speech. And I addressed each of those paragraphs pretty clearly. And I think the case in Watts, that's the famous case having to do with speech and true threat. And that case, I think, is pretty clear. It says a true threat, that is one where a reasonable person would foresee that the listener will believe he will be subjected to physical force upon his person, is unprotected by the First Amendment. None of the speech outlined in the government's indictment alleges speech that is of a nature that would subject somebody to physical violence upon his person. Mr. Santilli's been a journalist long before the incident that happened in Bunkerville, and he remained a journalist through the incident that happened in Oregon, where the government dismissed their case after evaluating more closely the speech that was fairly identical to the speech outlined in this indictment. The Department of Justice, it's my understanding, got involved and reviewed the speech and found that his speech was protected under the First Amendment. I think the speech here identically, where he calls for a protest out at Bundy Ranch for people who can lawfully carry firearms to come out to Bundy Ranch, which is a private area, private land, and protest the manner in which the government is acting. And I know part of the protest had to do with the First Amendment area that the government tried to corral people to express their First Amendment beliefs regarding the land issues out there. There's nowhere in the indictment that they allege any speech that crosses the line into unlawful speech as outlined in Watts. I think I've laid it out very clearly in my moving papers, and I'll submit it on that, Your Honor.
Thank you. Who will be arguing the government's position?
Aaron Cregan, Your Honor, the United States. Your Honor, let me correct Mr. Rasmussen's argument that the United States has formed some position that his conduct in Oregon was constitutionally protected. That is absolutely false. The government dismissed those charges in Oregon pursuant to an evidentiary ruling by the judge in Oregon that did not allow the government to offer evidence that he was not acting in a media capacity. So it is actually the exact opposite rationale of the one that Mr. Rasmussen has offered. Additionally, Your
Let me
Honor,
see if I understand you.
you're saying that the government elected to dismiss Mr. Santilli's Oregon prosecution because of a pretrial judicial ruling that he was not acting outside the scope of his profession as a
The judge
journalist?
in Oregon ruled that the government could not offer affirmative evidence that Mr. Santilli was not acting in a media capacity until raised by Mr. Santilli himself. And they thought that considerably circumscribed their ability to offer evidence in their affirmative case that would be sufficient to prove the charges.
So you dispute that anybody in the Department of Justice made the determination that the speech that was alleged to have occurred by Mr. Santilli that the government thought was a crime does not constitute an offense as a matter of law?
Correct. Nobody in the Department of Justice has made the determination that his speech is constitutionally protected.
Does government have anything else to add to its papers?
No, Your Honor.
All right, turning next then to Mr. Ammon Bundy's motion to dismiss docket number 833, which is the motion to dismiss that addresses a request to dismiss the indictment for destruction of evidence or the alternative for remedial jury instruction based on evidence that the defense has that the BLM and or other law enforcement agents shredded the documents before leaving the impoundment site. Mr. Hill?
Thank you, Your Honor. I'll start with any questions Your Honor might have that might save some time.
Well, first of all, your motion is supported by an investigator's declaration that says he went out to Bunkerville and obtained evidence of shredded documents in August of 2016, correct?
Correct, Your Honor.
And what happened between April 2014 and August of 2016 when your defense investigator became aware that somebody somewhere had plastic bags full of shredded documents?
The company that it's evident that the BLM contracted with to do the trash disposal at the site, recognizing the impact of the situation, kept control of what was deposited in
The Virgin Valley Disposal District kept the bags of shredded documents?
Correct. Well, it was Virgin Valley Disposal Company. I don't think it's a municipal entity.
All right, and so your client learned about them having these shredded documents how?
It's a small town, Your Honor, and it just, became known. I think important to that point is that the government and Ammon don't necessarily disagree that those documents those shredded documents emanated from the BLM's camp. Certainly, Ammon Bundy has displayed the reasons why, we certainly dispute what's in the bag of shreds to a certain extent, which is why Mr. Bundy...
Supporting declaration of the special agent in charge that's been in charge of the investigation since May of 2014 outlines in details what he did in order to investigate whether documents were shredded and so what they consist of. His conclusion, and based on the people he talked with and the documents that he's attached as an exhibit, are that the vast majority, and that's the key to your motion if I understand correctly, your reply, the vast majority of those documents are duplicate plans of the operation plan, lists of radio frequency lists and the like that the government believes is protected confidential information under the Criminal Justice Act. But you are concerned primarily, do you really have a dispute that those documents are not otherwise available to you by other means, and that those are copies of electronically stored documents that are otherwise available?
I mean, obviously, the incident action plan wasn't produced in discovery, so we would have to just go on the word of the investigator who sent it.
I understand, and that's why I'm asking, do you have any reason to believe that with respect to the category of documents that the government describes in the affidavit, that they were not mostly exactly what the government agent represents under penalty of perjury they were?
I have no reason to dispute that in that bag of shreds were those documents, among others.
And so, but the thing that you are most concerned about, and where your motion is primarily focused, is it is your position that one special agent claimant could not identify the authors of or the contents of shredded handwritten notes, correct?
Correct, and he spoke of the typewritten shreds in majority as opposed to saying definitively, having talked to the shredders, that's the only typewritten documents that were in there.
And with respect to the handwritten notes, your position is anybody that was out at the impoundment site is a witness in the case, and therefore any handwritten note might be potentially exculpatory evidence insofar as it would express the state of mind of a government agency, and state of mind is an issue in this case.
Correct, Your Honor.
And that's your argument in a nutshell.
In a nutshell, and above and beyond that would be what could be ferreted out regarding policies of what was supposed to be written down, what kind of notes were people ordered to pass around, all of which can only be elicited at an evidentiary hearing. For example, was there a policy that you have to write down X, Y, or Z and deposit it to a supervisor? Were they instructed?
What does that have to do with whether or not the evidence is exculpatory to your client as opposed to whether or not some individual agent or officer followed protocol?
It pertains to the first, certainly, but the only point would be, obviously, anything written down by a witness would be discoverable information, as a witness statement. It's just if Your Honor...
If spouse calls up and says, bring a loaf of bread home, that's...
Well, and that's where I was headed, Your Honor, to the extent that Your Honor thinks, as the government contends, that there's no possible way we could know what was in these notes. I would propose in the context of an evidentiary hearing, talking about what kinds of things, talking to supervisory members of the camp down there, what kinds of things are being written down. Was there, unspoken rules, we want you to write down this and give it to your supervisor? The government's position of Ammon Bundy can't identify what those handwritten notes were. Of course not. They destroyed them before anybody did anything with them. And only an evidentiary hearing could really allow us to get to the bottom of what was being written down in that camp on yellow legal paper.
Very well. The government's response, who is arguing the position?
Your Honor, we have...
Mr. Myrie, for the record.
Yeah, I'm sorry, Your Honor. Steve Myrie, on behalf of the United States. Our position is fairly well set out in our response to that motion. However, I point out it's quite a stretch. In fact, it's pure speculation to presume that, A, anything written down by anybody on April 12th was a quote-unquote statement, or B, that any of the shreds that Mr. Bundy raises in his motion were witness statements.
Well, was anybody else at the impoundment site a witness to the events? You concede anybody at the impoundment site was, in fact, a witness to some or all of the events?
Well, some events, yes, Your Honor, but recall that the ICP where this area occurred,
okay,
these agents were not...
That's government lingo for the command post.
Right, the command post where these events occurred were quite distant from where the assault was occurring down in Post 2. That's number one. But number two, the agents and the personnel who were working in the command post were not conducting investigations. They were running an impoundment operation, which this is not like it's an evidence locker or this was a witness interview room. There was no duty.
They were the ones that were charged with responsibility for collecting the cattle and going from there.
Correct. They were collecting cattle. They were providing security for the collection of cattle, but they were not conducting investigations. And it would be virtually impossible that during the events of the 12th, as they're trying to, as pointed out in Agent Clayman's declarations, they were trying to leave the area post-haste, that they would be taking witness statements, or people would be writing down anything that would remotely approach a witness statement. They were trying to get out of there. But, so, again, Your Honor, for an evidentiary hearing, the factual dispute has to be specific and definite. And here, there is nothing to be gained from the evidentiary hearing. There was no duty on the part of these individuals in the command post to be taking witness statements, making witness statements, or preserving witness statements. It just was not part of their duties. And in all these spoliation cases, as the court knows, there's the threshold issue is, was there some duty on the part of the law enforcement officers, and was that duty breached? And as a result of that, how is the defendant then prejudiced. Here we don't even reach the threshold issue of whether there's a duty because they were out there conducting an impoundment. They were not doing an investigation. As Agent Clayman's declaration points out, they had a duty to actually prevent the information that was being gathered in the dispatch center from falling into wrong hands, into the hands of those who are not authorized to have it. So they improvised, and the best way that they felt they could do this to prevent unlawful access would be to shred. At least that's what Agent Clayman's investigation revealed, and there's nothing in the moving papers to suggest otherwise. And therefore, not clear at all where we would go with an evidentiary hearing in this matter, because there's really no basis on which to find any sort of breach of duty.
Turning now to the two Cliven Bundy motions to dismiss. One is for a violation of the Speedy Trial Act, and I'll hear from Mr. Whipple on that. Since you filed this motion, I realize you're filing your motion to preserve the record and so forth. Part of the motion is based on a deprivation of counsel of his choosing, Mr. Clayman, not to be confused with the special agent Clayman. This is Klayman. The Ninth Circuit has now heard and decided an emergency petition for writ of mandamus with respect to the district judge's denial of pro hac vici application of Mr. Clayman. And do you have any status report on the pending petition for rehearing en banc?
No, Your Honor.
All right, and so let me hear from you on the merits. Now that the Ninth Circuit has at least, I don't expect you to accept that or like it, but that's what the Ninth Circuit has said. So,
I'm going to submit it on the writings. It's a discretionary matter. Obviously, we believe that the court should err when it's a discretionary matter in favor of the defendant. But I think I've pretty much laid out the issues.
You have, but I said it for oral argument, so I'm allowing you to be heard.
Yeah, I'm going to take some time on the next motion that I think is more applicable.
Very well. So let's turn to the next motion, which is the motion for to dismiss for lack of subject matter jurisdiction, which is docket number 892. In that, I have read your papers. You make arguments that this court lacks subject matter jurisdiction because the state of Nevada, not the federal government, owns lands within the Nevada territory. You make arguments that dating back to the Norman conquest that are constitutionally based, that the founding fathers in the 1776 and in framing the Constitution intended to abolish the feudal land system, that the Congress of the United States was given authority over public lands in the western states for the purpose of paying off, of selling and paying off debt, but that the intention of the federal Congress is always to hold the land for short periods of time, and the argument is made that the federal government has violated the compact that it reached by holding on to the lands effectively in perpetuity, and as a result, that the court lacks subject matter jurisdiction because this is state land, not federal land.
That's setting the stage, Your Honor. With the court's permission, can I pick up from there?
Certainly. I just want to let you know I've read your papers, I get your arguments. You also say that the United States is incorrect, that the United States obtained lands within the boundaries of what is now the state of Nevada under the Treaty of Guadalupe Hidalgo from the Mexican nation. So let me hear from you about why the Ninth Circuit's decision does not foreclose that argument.
Here's the issue, Your Honor. I think this is really a matter of first impression. I honestly believe that this is the first time that this issue has been raised before a court such as yourself. And I think we have to start with the understanding that Mr. Bundy's ranch is located in Clark County. And that when Nevada joined the Union in 1863, we had an enabling act that dictated how this territory that now is going to become Nevada was going to be handled. And I'll read here briefly in just a minute part of that Enabling Act, and it gets a little tedious, but the reason that's important is I want to compare that to the fact that Clark County was not part of Nevada when it joined the Union in 1864. Clark County became part of Nevada 2 years later in 1866. There's a difference. There's a difference in the Enabling Act in 1864, and there's a difference in when it became part of the state of Nevada in 1866. And I want to read that to you because that's important. The Enabling Act in 1864 specifically says in Section 4, third part, that the people inhabiting said territory do agree and declare that they forever disclaim all right and title to the unappropriated public lands lying within said territory, and that the same shall be and remain at the sole and entire disposition of the United States. That makes it very clear. Nevada, excluding Clark County, public lands are part and to be dictated by the United States, by the federal government. We get that. We understand that. However, Clark County was not part of that transfer. That occurred 2 years later in May 5th, 1866. And what's important, and the reason I read the first enabling statute is because it made an allowance for public lands. But in May 5th of 1866, it doesn't make allowance for public lands. And in fact, all it talks about is the mineral rights.
So you're arguing that the prior decisions of this court and of the Ninth Circuit in the United States v. Gardner have never reached the question of whether the Congressional Act of 1866 applies to land within Clark County that encompass the Bundy Ranch and surrounding areas.
That's correct. And furthermore, let me just kind of enhance on that because there's a nuance, there's a uniqueness to the whole aspect. First of all, 1866 just talks about, I'm just going to read where I think it's appropriate. It talks about Clark County and it says that all possessory rights acquired by the citizens of the United States to its mining claims, and I jump ahead, that shall remain as knowledge of existing mining claims. In other words, there's an absence. There's nothing, there's no language regarding...
Right. So the fact that the Act provided for the preservation of mining claims is an indication nothing else was preserved.
Exactly.
That's what your argument is.
Correct. And now let's jump ahead to 1979, because our own legislature recognized that there was an absence, that there was a problem there. And so they attempted to address it in 1979, and this is Nevada Revised Statute 321.596. And I'm going to jump to Section 4. And it says, the intent of the framers of the Constitution of the United States was to guarantee to each of the states sovereignty over all matters within its boundaries, except for those powers specifically granted to the United States. There is nothing in the 1866 Act that specifically grants that public property to the United States. Now let me just point out another differentiation, because I'm not here claiming that the Bundy Ranch belongs to Mr. Bundy. The question is, who owns that property?
Do you need to reach the question with respect to the offenses charged, all of which involve an offense against the United States under the provision of 18 U.S.C., and I don't have the exact citation right in front of me.
3231? Sorry, Your Honor, 3231?
That's where I'm going. Okay. So the issue is, who manages the land? Who manages the land in Clark County? And in fact, the state of Nevada, I believe, through the Nevada Revised Statute we discussed, is the proper entity that manages the land. Now, they've obviously delegated that to the federal government at different points, because the federal government has managed the land. Now, here is where it differentiates from Mr. Bundy. The basis for that management has been contractual. Every one of those other ranchers that are on that BLM ground every year sign a contract with the Bureau of Land Management dictating how much money they'll pay for every AUM, animal unit per month. What Mr. Bundy did was recognize that, and he opted out. He chose not to opt in. In fact, he opted out. So there is the issue. Do the federal government, do federal individuals have a right to come down and dictate how my client is supposed to manage his property? My position is they do not, and that is inherently the basis for...
So are you arguing, in effect, that the orders of this court, not me personally, but other judges in this district, beginning in 1998 through 2014, were void ab initio?
Well, I am, and not only that, they were never acted on. They expired. I mean, not only did we recognize they weren't proper, the federal government recognized them were proper and never acted on them, allowing my client to continue to remain on the property and ranch as he'd always done. That's not me. It's the federal government that made that determination. They're the one that chose not to enforce it. My client has never entered it, well, he hasn't.
Not to enforce what? Not to enforce, what is it that?
Enforce the orders that the court prepared. It would be, here's the issue, ultimately. We don't believe, and I don't believe there's any law that supports it, that the Bureau of Land Management has a right to go out there and tell my client how to run his cattle. However, there were federal agents out there. Okay? The issue is, were they properly there? My position is they were not, clearly not. There's no authority to dictate that they could be there. So does that give my client the right to protect himself? My suggestion is as follows. An analogy is if he's sitting here in Clark County, Nevada, doing his own job, doing what he wants to do, and we have a law enforcement agent from Canada that came down and attempted to arrest him, a different jurisdiction, a different entity, would he have a right to say no? Which is what he did. He went to the local jurisdiction, the local law enforcement. He called local sheriffs. They're the ones that resolved this. The federal government did not have subject matter jurisdiction. They shouldn't have been there from the beginning. It's that simple. This matter should be dismissed and everybody should go home and get on with their lives because the federal government shouldn't have been there from the beginning. There's no law to support it, and this is a nation of laws.
Thank you, Mr. Whipple. Who will be arguing the government's position?
Your Honor, Aaron Cregan for the United States. Since Mr. Whipple has stated that this is a nation of laws, I think it's important to point out that his reply suggests that it is appropriate for the citizens of this country to use violence whenever they disagree with anything that is done by a federal officer.
That's not exactly what his reply said. His reply says that America was formed as a result of a revolution in which people took up arms against the colonial powers.
And that is to be a model for suppressing, instead of moving to suppress a search warrant, you should violently oppose an officer who tries to execute a search warrant that you don't think is valid. Instead of acceding to be arrested and then fighting the arrest is improper, you should violently oppose an officer who tries to arrest you. And when Mr. Whipple is discussing saying no to an officer from Canada, this is a violent opposition. That is not the law. That is not what a society of laws does. And every court that has passed on it has found that it is the duty of a citizen to accede to lawful orders of a police officer executing their duties. If they don't agree with them, they can fight them later.
All right. Please.
The statutes which Mr. Whipple is discussing discuss official duties. As the Ninth Circuit found in Wolfong, that means that if the officer is engaged in his daily responsibilities, not on a frolicking detour, not that the duties that he's executing were not later found to be invalid.
Right, your remedy is to go back to court and take whatever civil action or other remedial action against the officer, not disobey the orders, what the government's position is.
Correct. But what Mr. Whipple is also asking this court to do, besides to legitimize violence, is to render an advisory opinion.
I don't need that inflammatory language, okay? Because it's not helpful.
Your Honor, what Mr. Whipple is asking is for an advisory opinion on who owns the land in question. Because none of these statutes have as a jurisdictional requirement that they occur on federal land, there's no relevancy to this pending case to the question of who owns the land. It may be the genesis of the case factually that Cliven Bundy had a civil dispute with the United States and that it ultimately led to the events of this case. But it is not relevant to whether these charges can proceed. It is not relevant to a Rule 12 determination because it is not an element of any of these offenses. And even if things were as he argues them to be, that would not change that the United States has jurisdiction under 3231 to prosecute people who interfere with federal officers, who assault federal officers, who threaten federal officers, and who extort federal officers.
All right. Turning...
May I respond to that briefly?
Briefly, Mr. Whipple. Your brief is very thorough about your position in combination with your reply.
You know, I asked to reply because this truly is a case of first impression. How often is it that we have a cattle rancher from Clark County, Nevada, standing before the court? It's just very unique that we have...
Well, Mr. Bundy has been here many times before.
It's unique that we have a rancher that opts out. It's unique that it becomes an issue in a county that's not part of the original state, and it becomes part of the, it's becoming a territory and becomes a state. My response to you is this is a first impression, and if I were in their position, what else could I argue? Of course, I'm going to argue this. They're not addressing actual facts of this case. They're not addressing the actual fact that there is no law that allowed the law enforcement agency from the Bureau of Land Management to be there to begin with. They're avoiding that. They're trying to they're avoiding it because they have no answer. And what I'm trying to get the court to recognize is this is something that is very unique and different, and I believe it's something
Right, I clearly understand your arguments. Is the Enabling Act of Congress in 1866 created this scenario in which Clark County was exempted from federal lands.
Yes. Thank you.
All right. And the last motion on calendar is Mr. Dave Bundy's motion to dismiss for insufficiency of the indictment and for outrageous government conduct. Is there anything you need to add to your papers, Mr. Potter?
Your Honor, I was just pointing out that we've been in a unique situation. We haven't given the court an opportunity to expand the Iqbal Twombly type rationale. These are just rote legal conclusions.
And for the record, you're talking, not everybody knows what you're talking about. In civil cases, the Supreme Court has decided a couple of cases in Iqbal and Twombly saying that more than formulaic recitations are required for a charging document to pass muster and get to the next stage.
That's correct, Your Honor, and more litigation has been come through the federal court system as a result of those cases. In this particular instance, all we have are rote conclusions. They don't talk about how my client was a leader, what he did, what demonstrates who he led, who the contractors were that he was supposed to have been involved with, the nature of what occurred in terms of violence. There are hundreds, if not thousands, of people out there. My client was there with his wife and family. He was then recruited. That's the other issue that we talk about on the outrageous government conduct. He was recruited by Agent Love to help be a peacemaker. He did that. He then was also worked with Sheriff Lombardo in a unique situation in trying to become a peacemaker once again with the county police. He was in a situation that, but for their actions, he would have remained as an individual standing there with all the other thousands of people. He was there to peacefully protest and was doing that at the point in time. We rely upon the case law dealing with the analysis, and we did set forward that in our moving papers, but I think he is in a unique situation. Magistrate Judge Fehrenbach recognized that even making the determinations and pointing that out, that he was in a unique situation, almost as what we used to call posse comitatus. They asked him to help out the government. He helped out the government. They asked him to help out the police. He helped out the police. And actually, what was submitted to the court shows that, in fact, Sheriff Lombardo congratulated him in being a peacemaker and that he knew that it would work out.
Thank you. The government's response? Ms. Ahmed?
Your Honor, does the court have any specific questions for me? Or I don't think that Mr. Potter raised anything other that was already in his papers. So unless the court has specific questions, I would.
No, I was just giving you an opportunity to respond to Mr. Potter's oral representations.
Your Honor, we would then rest on our papers. Thank you.
Very well. Then the court will take all of the motions under submission. I will...
motions that we haven't reached yet. On the agenda, we have 5 motions to dismiss. We addressed the first one, and then that's when we took our break and we went to the other ones. We have 711, 712, 754, and 757.
I do not need oral argument on those matters, and I will take the matter under advisement. What I'm going to try to do for you is get the order out first on the motion to sever, because I know everybody wants to know that, and then second on the 924C crimes of violence issues, and then work myself with getting out written decisions and orders as expeditiously as possible so that everybody knows what the rulings of the court are so that you can act accordingly.
Respectfully, we've had argument and everything else. I would like the opportunity to go through these last four motions.
The rules do not require me to hold any oral argument at all, Mr. Norwood, and so I reviewed these very carefully. I have draft orders that I've been working on. I've asked the questions that I need to ask in order to finalize decisions and orders in this case, so I'm taking matters under submission. Mr. Santilli, I don't have to hear oral argument at all. All of the positions that have been taken in all of these motions are on the record for any member of the public that wants to see them, and any member of the press that wants to see them. So a lot of these arguments are rehashing the same type of things with a little different nuance, and it is now almost 12:30. We've been here for 3 hours, and I'm using my discretion to take the matters under submission. That's the order of the court. We are adjourned. Thank you.
All rise.
Resistance to tyranny is obedience to God. Resistance to tyranny is obedience to God. Resistance to tyranny is obedience to God.